Good morning. I'm Dr. Selvakumar from Agricultural Biotechnology, Bharat Institute of Higher Education and Research. Today, we are going to discuss about intellectual property rights. Subject code U18HSBT601. Course name Entrepreneurship Development. So welcome you all for my class. Right. Now I'm going to IP. What is IP? Intellectual property. What is the definition of IP? The intellectual property or IP refers to the creations of the mind, such as inventions, the literary and artistic works, symbols, designs, names, and images used in the commerce is called intellectual property. What is IPR? Intellectual property. The intellectual property rights or the IPR is the right which give monopoly of any intellectual creation of mind. It is a combination of science and technology or both. It is given for any new creation, such as the composition of music or the writing of a book or the new invention. And it is not for any mathematical formulas. Next, I'm coming to the kinds of property. First, I'm coming to the classifications of property. There are different kinds of property. Number one, movable property. For example, furnitures, car, bikes, pen. What is immovable property? Land, building, etc. Next, intellectual property. For example, books, inventions, etc. Next, I'm coming to the types of IPR. It is the following types. Number one, patent. Number two, trademark. Number three, geographical indication. Number four, copyright. Number five, neighboring rights. Number six, integrated circuits. Number seven, industrial design. And number eight, the trade secrets. Next, I'm coming to patent. What is patent? A patent is an exclusive right granted for an invention, and generally speaking, a patent provides the patent owner with the right to decide how or whether the invention can be used by others. But patent is a local monopoly granted by government. And this patent allows the inventor for exclusive right to make or use and sell an invention for 20 years. The patent applicant must demonstrate to the patent office that an invention, discovery, or design is non-obvious, novel, and useful. So it cannot be obvious considering the current technology. So, the utility or functional patent. The utility or functional patent protect the way an article is used or works. It must be reduced to tangible form. Next, I'm coming to the plant patent. The plant patent. The plant patent protects new asexually reproduced distinct variety of plant other than a tuber propagated plant or a plant found in an uncultivated state. Next, I'm coming to design patents. The design patent protects the way an article looks, lesser term protection, that is approximately, and the design patent consists of the visual ornamental characteristics embodied or applied to an article of manufacture. Second, coming to a patent holder gives notice that an article or design is patented by placing on it the word patent or pat plus the patent number. Suppose if a firm uses or sells another patent design or product or process without the patent owner's permission. So the tort of patent infringement exists. Next, what are the basic requirements for a to obtain a patent? The new invention must be number one, the novel. What is novel? Novelty. So not known or used in this country and not published anyway. The data should not be published anyway. Non-obvious. It cannot be an obvious the way to do something. Use must have some application, even if not commercially. Next, I'm coming to the patent applications. The priority between two inventors generally the person first to invent and use the product is given the patent, even over an earlier filer. The next one, the prior say it must apply for a patent within 1 year of selling the product. So the provisional patent application, the shorter, the cheaper way to file for a patent temporary to determine if the invention is commercially practical. Next, I'm coming to the major issues of major patent issues. The human genome and gene patents, pharmaceutical related patents, agrochemical related products. The patent of microorganisms. The Budapest, the city name is the Budapest. So the Budapest International Microorganism Deposit System in the brewing and baking industries. The yeast has traditionally played an important part, and the patents for new types of the yeast were granted to Belgium in 1833 and in Finland 1840. The Budapest system provides a practical business solution when pursuing the patents, especially involving the biological material in some 80 countries through the recognition of one international recognized deposit with an international depository authority, IDA, I for international, D for depository, A for authority, international depository authority. Next, I'm coming to how can you patent a microorganism? Suppose you may be found a new microbe, and how can you patent a microorganism in IUU? All patentable inventions must satisfy essentially the same criteria. That is, the invention must be novel and not obvious. It must have some industrial use, and the description part of the patent application must enable a person's skill in the relevant area of technology to put the invention into practice. Next, I'm coming to the novelty of microorganisms. In the patented terms, the novel means not previously made available to the public. So it should not be available to the. So the first person to find and isolate a new bacteria from a soil sample, for example, might have made a potentially patentable invention. If the bacterium is claimed in the patent application in the isolated form, that form will be novel and over the previously known mixture of the bacteria with numerous other microorganisms in the soil. Third, a novelty of microorganisms. Next, I'm coming to the patent deposit. If the bacterium is shown to have some practical application or usage, and it is sufficiently different from other bacteria which have previously been and known for that use, then the use and inventive state, the hurdles are likely to be overcome. The number of countries and the patent offices, especially the European patent office, need a sample of the microorganism and to be deposited under the Budapest Treaty before the patent application is filed. Next one, next. The depositor should ensure that the adequate time is allowed for the delays in the mail or the customs formalities. The incorrectly filled in the forms and the possibility that the sample is found to be non-viable. What will be non-viable? Non-living. So the care should be also be taken that the deposit is made in the name of applicant for the. Next, I'm coming to the submitting details of deposit. So most of the patent officers require the details of the International Depository Authority, that is IDA, the deposit number and the deposit date to be included in the patent on the filing or to be added to the patent application within a set of time, approximately 16 months of the earliest priority date. Next, A short description of the characteristics of the particular microorganism might also have to be included in the patent application. So the practice on these points varies from country to country, and it is therefore the prudent to include all of this information in the patent application on filing if next one to trademark. What is trademark? The trademark is a recognizable sign or design or the expression which identifies the trademark owner can be an individual or business organization. A trademark is located on a package or a label on product itself. The label of the product itself. Next, I'm coming to the types of trademarks. There are different types of trademark. So the trademark affixed to the goods, that is trademarks affixed to the goods. Service marks identify the services, not goods. Certification marks, the marks used by an organization to attest that products meet certain standards. Next, collective marks, the marks that identify the members of an organization. So trademarks, service marks, certification marks, and collective marks. Next one, so a trademark may be designated by the following symbols. The trademark symbol, which is the letters TM in superscript, denotes for an unregistered trademark a mark used to promote brands or goods. Next, which the letter is SM in transcript, that is superscript, for an unregistered service mark, a mark used to promote or brand services. The letter R surrounded by a circle for registered trademark. So TM, the unregistered trademark, that mark used to promote or brand goods. SM, a mark used to promote or brand service. The R surrounded by a circle for a registered trademark. Next, I'm coming to the geographical indicators. Geographical indicators. The geographical indications and application of origin are the signs used on the goods that have a specific geographical origin and possesses the qualities underlying geographical indications and appellations of origins or signs used on the goods that have a specific geographical origin and possesses qualities. A reputation or characteristics that are essentially attributable to the place of origin. Most commonly, a geographical indications includes the name of the place of origin of the goods. For example, Banarasi sarees, Dindikkal locks, etc. Next, I'm coming to trademark. What is trademark? Any word, any phrase, any symbol, any design, sound, smell, color, their product configuration, group of letters or numbers, or combination of these adapted and used by a company to identify its products or its services and distinguish them from the products and services made or sold or provided by others called trademarks. A distinctive mark, motto, device, or implement that a manufacturer stands or prints on its goods. What are the main uses of the trademark? Basically, the trademark assists customers in identifying the product without confusion. If a business uses the trademark of another, the consumers are misled as to who made the goods. The uses of. Next, I'm coming to what can be trademark. What can be trademark? The words that are used as the part of a design or device, or the words that are uncommon or the fanciful words may be trademark. Okay. The next question arises. What cannot be trademark? Personal names, descriptive, or the generic words, or a particular name of the place. For example, carpet, pencils, books, Chennai, Adayar cannot be. Next, I'm coming to the international protection trade. The registration in each foreign country. Registration in each foreign. Second one, the use of as variety of trades. Next, coming to CTM, Community Trademark Registration. Underline Community Trademark, Community Trademark, Community Trademark Registration for all countries, which are the part of European Union. The international protections of the trade. So the registration in each foreign countries, the use of as variety of trades. Next, the community trademark registration for all countries, which are the part of the European. Next, I'm coming to copyright. What is copyright? The copyright, it's an intangible right given to the author or the originator of certain literary or artistic protections. The works created after January 1, 1978, they are automatically given the copyright protection for the life of the author plus 70 years. And the copyrights owned by the publishing houses expire 95 years after publication or a 120 years from the date of creation, whichever is. The copyright, if multiple authors, the expiration is 70 years after the death of the last surviving. The facts are not copyrighted. The employer is the owner of the work for hire the work created within the scope of employment unless otherwise agreed. The Berne Convention provides the international protection for copyright for citizens of the 96 signatory countries. The copyright exists automatically upon the creation of an original work, but the placement of copyright symbol, the letter capital C covered by the circle, gives notice and to judicially enforce the copyright records. The registration with the Indian Copyright Office. Next, I'm coming to the copyright fair use determination. The purpose and character of use, including whether such use is of a commercial nature or for non-profitable educational purposes. Second, the nature of the copyright works. Number 3, the amount and sustainability of the portion used in the relation to the copyrighted work as a whole and the effect of the use upon the potential market for or the value of the copyrighted work. So, computers. The software copyrightable aspects. There are 3 important things. Number 1, code, C-O-D-E-S, code. Both source and object codes. Structure, how a program accomplishes a task. Third, look and feel, the way a program looks and uses the symbols. 2, Internet. The Digital Millennium Copyright Act. Digital Millennium Copyright Act, DMCA. This act makes it illegal to delete the copyright information such as the author's name and then distribute the work through the internet. Next point. It is also illegal to circumvent the encryption or the scrambling devices. So, the examples of copyright. Writings, that includes textbooks, novels, chapters, etc. Second one, the computer software. Number 3, the song writing, theme song, devotional song writing. Number 4, the recordings of the songs. My PPT slides, although some parts included fair use copyrighted material from textbook authors. Next, I'm coming to the trade secrets. A trade secret is a formula. Trade secret is the formula. Device or process or method or the compilation of information when used in the business gives the owner an advantage over the competitors who do not know it. Second comment to the Economic Espionage Act of 1996. The Economic Espionage Act of 1996. This statute prohibits any attempt to steal trade secrets for the benefit of someone other than the owner, including for the benefit of any foreign government. Next, I'm coming to trade dress. The trade dress is a common form of intellectual property rights. The trade dress is a legal term of art that general. So, the trade dress refers to the characteristics of the visual appearance of a product or its packaging, that means design of building. that signify the source of the product to the consumer is called trade dress. Next, I'm coming to WIPO. WIPO, World Intellectual Property Organization. The World Intellectual Property Organization, WIPO, is one of the 17 specialized agencies of the United Nations. The WIPO was created in 1967 to encourage the creative activity to promote the protection of the intellectual property through the world. Next, I'm coming to the WIPO currently has 189 member states and is headquartered by Geneva, Switzerland. The WIPO Lex is an online database of national legislation and international treaties in the field of intellectual property. The maintenance and development of database is exercised by the World Intellectual Property Organization. Thank you.